Welcome to this episode of Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers, where we share practical family law insights for people navigating separation, parenting and property matters. Today we're talking about how property is divided after separation in Australia and what the 4-step legal framework actually means for your situation, and why the outcome is almost never 50-50. Most people I speak to for the first time think property settlement means a courtroom, a judge, and a 50-50 split. And when I tell them that's not how it works, that there's no automatic formula, that most matters never go near a court, and that the same asset pool can produce very different outcomes depending on the people involved, I see genuine surprise. Let's start with the framework. Property division in Australia follows 4 steps, not a formula. 4 steps that lead to a judgment about what is fair given your specific circumstances. Step 1 is identifying the property pool, everything. Not just the house and the bank accounts, but superannuation, business interests, family trusts, self-managed super funds, investment portfolios and liabilities, mortgages, credit card debts, personal loans. The full picture on both sides. And here's the thing many people miss. It doesn't matter whose name the asset is in. If it came into the relationship or was built during it, it generally forms part of the shared pool. That's a significant point for people who assumed that what's in their name is theirs. Step 2 is assessing contributions. Financial contributions, income, assets brought in, inheritances, gifts, and non-financial contributions, caring for children, managing the household, supporting the other person's career or business. Both are formally recognised under the Family Law Act. A parent who spent years as the primary carer and stepped back from paid work has made substantial legal contributions to that asset pool. The law acknowledges this, and it reflects in outcomes. Step 3 is future needs. This is where the picture of each party's life after separation comes into focus. Age, health, income earning capacity, whether one person will be the primary carer of the children going forward, how the relationship has affected each person's career prospects. A parent returning to the workforce after many years as the primary carer is in a fundamentally different position to a spouse who continued building their career throughout the same period. The court, and we as advisors, take that seriously. Step 4 is the just and equitable test. This is the standard the whole process is built around. Is the proposed outcome fair, given the full picture? Not equal. Fair. That distinction matters enormously. Identical asset pools produce different outcomes when the contributions, circumstances, and future needs of the parties are different. There is no calculator. There is no formula. There is a qualified judgment about what is fair for these particular people in these particular circumstances. Now, 2 significant changes came through in the 2024 and 2025 family law reforms, and I want to make sure people understand them. The first is mandatory financial disclosure. Both parties to property proceedings are now required from the outset to provide full and frank disclosure of their financial position. Assets, liabilities, income, financial resources. The court's powers to respond to non-compliance, including concealment of assets, have been substantially strengthened. The second is the formal recognition of financial abuse and coercive control. Courts are now required to consider whether either party engaged in controlling financial behaviour during the relationship, restricting access to money, making major financial decisions unilaterally, undermining the other person's financial independence. This is a meaningful change for clients whose experience of the relationship included that kind of control. Here's something that consistently surprises people. Property settlement does not require court proceedings. The 4-step framework applies whether you're negotiating directly, working through family dispute resolution, or going through formal mediation. What changes is the process, not the legal framework. At Village Family Lawyers, we operate with a resolution-first philosophy. Approximately 90% of the matters we support through mediation resolve without going to court. That outcome doesn't happen by accident. It comes from clear early advice, strong preparation, and a commitment to resolution that puts the client's long-term interests first. What I will say is this: any agreement reached outside court must be formalised to be legally binding, either through consent orders approved by the Federal Circuit and Family Court of Australia or through a binding financial agreement. Reaching agreement is one thing, making it stick is another. If property settlement is something you're facing or likely to face, the best thing you can do is understand your position early, before informal arrangements are made, before decisions that are hard to reverse get made by default. Village Family Lawyers offers a free 15-minute discovery call as a starting point. No commitment, no pressure, just a conversation so you can understand whether we're the right fit. From there, a 90-minute initial consultation gives you a clear picture of your property pool, your rights, and a practical action plan. You can book via villagefamilylawyers.com.au or call 1300 413 We're also linking the full article in the episode notes. This has been Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers. Thank you for listening.